Welcome to the current federal tax developments for the week of March the 23rd, 2026. Current federal tax developments are brought to you by your state society of CPAs. We're going to be going over a technical overview of things that went on in the past week in taxes. It was a busier week than we've had recently, so we have a number of things to cover this week. So, what we're going to look at here is we're going to start with a critical tax court decision, looking at corporate capacity to litigate and a state law reviver and whether that solves a problem. The issue is one we've addressed before, and this involves the state of California, which is also a state that's been addressed before in this area. What's missing this time, though, is whether if a corporation runs afoul of this problem, can they depend on the Batchelor case to argue that they should have a chance to argue, that, hey, I should be able to do it past the due date and fix this problem based on equitable rules. And so we'll discuss that. That's why we have this one as a published case this week. We're also then going to take a look at Notice 2020-620, which extends digital asset identification relief for brokers. And then following that, we'll look at Revenue Procedure 2020-617, which allows you to unwind what were previously irrevocable interest limitation elections following the passage of the One Big Beautiful Bill Act. We'll also cover the Ninth Circuit decision regarding standing to sue over the IRS's automated ERC disallowance program, which is a case that we've been following since it first showed up in the district courts here. We'll take a look at newly finalized substantiation rules under Section 274 for unmarked emergency vehicles. A tax court decision clarifying whether a partnership can assert Fifth Amendment due process rights on behalf of its members under the Bipartisan Budget Act audit regime. And lastly, the strict application of the claim of right doctrine to Social Security repayments. So, our first development, we're looking at a trap for the unwary when corporate taxpayers are moving forward in tax controversies. And this case is Arbor Vita Corporation doing business as Media Diagnostics versus Commissioner. This was a published tax court decision, 166 TC number 5, and the decision was issued on March the 16th. Now, here's the problem. Before a corporation can file a tax court petition with the tax court, they need to check and make sure that their entity status is active and in good standing under state law. Because what you may find, if that is not the case, even though the IRS can move forward with grabbing assets, basically doing the assessment and coming after assets and doing the other things moving forward, you really can't litigate in tax court until you repair the corporate structure, right? In this opinion, it was authored by Judge Landy. It underscores exactly what happens when federal rules of practice clash with state corporate suspension laws, and why you can't simply rely on state Revivor statutes to save a defectively filed petition. So let's take a look at a case overview here. Right. As we noted, the case of Arbor Vita is how the court analyzed the interplay between a state corporate suspension and the boundaries of equitable tolling. That's the new thing in the midst of all this. Under Tax Court Rule 60C, the capacity of a corporation to litigate is strictly determined by the law of the state in which it was organized. That's probably a good point to recognize here. The fact that this case was ruled under California law. If your corporation is not in California, right, we're not worried about its status to sue, because it is, let's say, an Arizona corporation, a Utah corporation, New Jersey corporation, whatever it might be. You need to understand that the rules may be different and how the court would apply them. So this is important, but it does suggest, I think why the court has this one as a published opinion, that you simply can't say that, because of Batchelor, even though we didn't have a right to litigate, we didn't have a right to sue, as long as we get ourselves reestablished eventually, we should be able to argue equitable tolling. That's kind of what they're looking for here. So the real core issue here before the court was whether a state's certificate of reviver, in this case under California law, could retroactively cure a tax court petition that was filed when the corporation's powers were suspended. Quite often when your corporation gets suspended for non-filing of a report, non-paying of a fee, In California, non-paying of corporate taxes, you'll find that if you get rid of the problem, there is a procedure you go through where you essentially retroactively revive the corporation. And this is the context of a certificate of reviver. Now, in this case, the question about the reviver carried weight because the taxpayer argued Supreme Court's landmark decision in Batchelor, which reclassified certain filing deadlines as non-jurisdictional and subject to equitable tolling, should essentially afford them procedural flexibility to retroactively validate their position. They're saying, look, I know we filed a petition when the corporation didn't have the right to file one, but we got the reviver. And so because of that, even though we might agree with you that we can't go back and fix it then, we should be able to use that as a reason why we should have permission to late file and continue our battle in the tax court. Now, let's walk through the factual timeline laid out here. Arbor Vista was a California corporation owed unpaid unemployment taxes and had an Internal Revenue Code section 6721 civil penalty for the 2017 tax year. The IRS filed a notice of federal tax lien, and the taxpayer requested a collection due process hearing. Not surprisingly, when they have problems paying their taxes, they also may have other problems paying things, and that's kind of where our problem started. On July 1st, 2024, during the administrative process, the California Franchise Tax Board, which for those of you not used to California taxation, that's essentially the equivalent of a Department of Revenue in most other states, in this case, suspended Arbor Vita's corporate powers under the California Revenue and Taxation Codes 23301 and 23302 for failing to file state tax returns. As I say, this is not an unusual situation for someone that has issues with the IRS. They're having issues with the state, and they're just, things are falling apart. They're not filing returns, or they're not paying the returns. Well, California, you lose your status when you do that. While that corporation was still in the suspended mode, the IRS Independent Office of Appeals issued a notice of termination on March 6 of 2025. The taxpayer then filed a tax court petition on April 3rd, so acted, within the time frame. Now, strictly speaking, this petition is on time. It was well within the 30-day statutory period to file it under Section 6330D1 for this type of a claim. However, because the corporation was still suspended under California law, it lacked the legal capacity to act under Tax Court Rule 60, parenthesis C. The catch here is the corporation didn't exist. It was effectively a non-entity. Non-entities can't file petitions, basically, in most state law. Now, the taxpayer did eventually pay its state obligations and received a certificate of reviver, but that did not happen until September 17, 2025. And that's months after the 30-day statutory window to file a valid petition had basically shut down. So there's an issue here. We have a petition filed timely, but we didn't exist when we filed it. And then we have basically, we've got everything straightened out with California. We've revived our corporation, but we're past the date to file a petition. Because we could file a valid petition today. We have a right to go to court, but of course, we're past the deadlines. So they're saying one way or another, equitable relief should allow us to move forward on this case, is what the taxpayer is arguing. Now, what they attempted to defend its position by arguing that California's certificate of reviver should retroactively validate the petition filed during suspension. And they leaned heavily on a Supreme Court's landmark decision in Batchelor, right, for that kind of relief, right? That was if you recall, Batchelor altered the landscape of tax court deadlines by reclassifying the 30-day collection due process deadline under 6330D1, this deadline, as an ordinary non-jurisdictional deadline that is subject to equitable tolling. Prior to Batchelor's, these filing periods were strictly jurisdictional, meaning a lack of capacity during the filing window automatically killed the case and rendered any state relation back doctrines entirely moot. Because Batchelor created potential procedural flexibility, the judge in this case was compelled to carefully consider and scrutinize whether California's specific relation back rules could now save the taxpayer petition. So key to understand this answer is not being decided by the court under federal law directly. It's saying the key issue before us is going to be state law. What does California say about its Revivor statute? Okay. So now let's take into the mechanics of California's law, since that's going to be the key here. The tax court must apply the law of the state of organization. California, in this case, if for you guys who aren't in California, or corporations that aren't California corporations, we're going to look to the state the corporations organized it for its rules. So while California does allow procedural acts to relate back upon Revivor, it strictly prohibits substantive acts from doing so. Okay, that's going to be the difference. The death knell for Arbor Vita was California Revenue Taxation Code Section 23305A, which mandates any corporate revival shall be without prejudice to any action, defense, or right which has accrued by reason of the original suspension. The tax court reasoned that exactly 31 days after the notice of determination was issued, the IRS accrued a valid statute of limitations defense because no legally valid petition had yet been filed. Retroactively validating Arbor Vita's petition in this case would prejudice this accrued defense, which is explicitly prohibited under the California law. The court also dismissed the taxpayer's attempts to compare the petition to a California notice of appeal, knowing the tax court functions as a trial court, not an appellate court. There was a second case they tried to bring in. They said, nope, we're a trial. This wasn't filing for an appeal. This is different in that case. Right? So what's the holding and the basically the final plea by the taxpayer for equitable holding? Tolling. The tax court held that equitable tolling mechanically could not apply here. Equitable tolling is designed to extend an otherwise discrete limitation of period. However, Arbor Vista actually filed its petition on time, within the initial 30 days, but did so without the capacity to litigate at the time. Since it was timely but legally defective, there was no deadline extension the court could logically grant. Now, whether the U.S. Supreme Court would see it that way would be another question. Because, the tax court is not really wanting to expand Batchelor. That's become clear over time. Now, this case was dismissed for lack of jurisdiction. And the critical takeaway for anybody in practice is that Batchelor is not a cure-all. Too often we get a Supreme Court case and practitioners, be they attorneys or not, often seem to start figuring, well, that's a catch-all solution for everything. It's a potential solution. A potential doesn't mean it's going to work, and certainly doesn't mean it's going to work easily, unless you have the exact fact pattern, which this was not a Batchelor. You have a risk that the tax court is going to differentiate the case and saying the Supreme Court case didn't affect it. So, for practical matter, you got to get the entity fully revived and active before the expiration of the tax court filing deadline. Or you may have given the IRS the perfect defense, at which point you need to pay the tax, whatever, and sue for refunds if it was deficiency notice. In this case, you just blew your chance of collections at getting some collection relief because, you basically filed your petition and you didn't exist when you tried to do it. Now, for those of you with the video, we have up now a graphic visual summary of the jurisdictional trap that we were looking at here. Right? The infographic illustrates a chronological timeline. Step 1 shows the corporate suspension. Step 2 shows the timely but invalid petition filed without capacity. And step 3 highlights the too late revival, right? Why it came in. The bottom half of the graphic summarizes the legal hurdles in this case. Rule 60C defers to state law. And again, that could be helpful to you. Now, if you're in California, California's no prejudice rule protecting the IRS accrued defense was a big problem, and the possibility of implying equitable tolling to a technically on time but legally void petition. So essentially, the court is holding that by having attempted to file a petition and doing so in a timely manner, but doing so in a way that was legally defective, you can't get equitable tolling. So whenever you have this issue, make sure your clients, especially ones in collections, make sure that they are in compliance with all rules that will keep their corporate charter valid in the state they're organized in. Otherwise, you may not have any way, tax court may not be an option. And then you've got to realize Tax court is not an option, at least until you can get it fixed. So, that's something to keep aware of in this area. Let's go to the second major development. This is a piece of administrative guidance that was being anticipated for anybody managing clients who have digital asset portfolios, notice 2026-20. Under Internal Revenue Code Section 1012C1 and the final regulations, taxpayers must apply ordering rules on an account-by-account basis when disposing of specified digital assets. Basically, crypto, and if anybody still got an NFT, we have that. Crucially, if the assets are in a broker's custody, the regulations state that adequate identification is only made if the taxpayer specifies to the broker the exact units to be sold no later than the date and time of the disposition. If the taxpayer fails to do this, they are forced into a strict default first in, first out FIFO rule. As we'll discuss here shortly, the brokerage industry's technological limitations make strict compliance with this rule practically impossible. So the IRS has now extended relief in this notice. So what are the specifics of 2620? What it does extends temporary relief for digital asset basis tracking. For context, Internal Revenue Code Section 1012C1, the final regulations under Treasury Decision 10,000 require account-by-account application of ordering rules for digital assets. Under Treasury Regulation 1.1012-1J3, 2, if the assets are held by a custodial broker, the taxpayer must specify to the broker the exact units to be sold no later than the date and time of disposition to achieve adequate identification. If the taxpayer fails to do so, under Reg Section 1.1012-1J3I, there's mandated a strict FIFO rule. Notice 2620 extends the relief from these strict broker communication requirements that was originally imposed under 2025-7 temporarily. So next up is, what's the rationale for extending? The reality is that custodial brokers remain technologically unprepared to accept specific identification instructions from their customers. While the Treasury Department has been informed that brokers have implemented systems to report gross proceeds for transactions in 2025, their basis tracking systems are significantly lagging. Currently, most brokers are not ready to accept specific lot instructions other than basic standing orders. Without this administrative relief, taxpayers would be unfairly and automatically forced to default FIFO simply because of the brokerage industry's technological limitations and, slow rollout, shall we say, of this type of a feature. So here's the mechanics of the extended relief. 2026 establishes a new relief period that begins on January 1st, 2025 and runs through December 31st of 2026. Fundamentally, we're extending the relief by 1 year. During this 2-year window, taxpayers may bypass communicating their lot selections directly to their broker. Instead, taxpayers can make an adequate identification, that's a term used in the notice, internally in their own books and records. This can be done by recording specific identifiers such as purchase date, time, and price, or by establishing an internal standing order before the units are disposed of. It's important to note a key limitation of this. This relief only applies to digital assets held in custody of a broker, not any they might hold on their own. Additionally, if a taxpayer is utilizing Revenue Proc 2024-28's basis allocation safe harbor, if that was a related item from last year, they must satisfy those requirements before relying on this relief. Same thing as the original ruling. Now, obviously, this is an impending collision course coming. The 1099-DA mismatch problems. Notice 2026-20 introduces a critical new provision for tax practitioners found in Section 4.05, entitled Adequate Identification. Here's the issue. The broker form 1099-DA reporting will become active in 26. That's not been delayed, which is right in the middle of this extended relief period because taxpayers are permitted to maintain separate internal books for lot identification without telling their brokers. The IRS explicitly anticipates that the acquisition date and basis reporting by the brokers in 1099-DA will not match the taxpayer's internal records. As we know, that's normally a bit of a problem. So how do we resolve the mismatch? To cure the discrepancy, Section 4.05 dictates that taxpayers made adequate internal identification. These books and records will supersede the 1099-DA for income tax purposes. However, this modification shifts the burden of proof heavily on the taxpayer's contemporaneous record keeping. Please remember, this is not something you can fix on exam by having the client write something up. You must ensure your clients are rigorously documenting their lot selections internally prior to execution. Once they make the statement, or they do something, say, "Oh, I didn't know anything about this until I got your letter," and the CPA told me, "Oh, I had to do this." So I've gone ahead and done it. Okay, they just admitted they don't get it. Okay. You cannot try to reconstruct these identifications at tax time or at exam time. The internal records must be established correctly to override the broker's reporting. So the clients have to understand they can't come to you next April and say, "Well, pick the ones." No, you're not allowed to use hindsight. They have to come to you with these things already picked. And in theory, if they pick them, they can't undo that pick. So, yeah, I don't know if, how many clients will not screw this up, and basically not have the records. Remember, the burden's on them. It's not up to the IRS to prove they didn't do it. It's up to them to prove they did. Okay. So again, back to infographics time. So those of you on the podcast, if you go download the slides, you can see these, but we have them here. So we have summarizing this crypto tax relief, I should say, infographic. It's a cheat sheet that contrasts the standard regulatory requirements against the temporary relief window that spans January 1st of 25 through December 31st of 26, calendar years 25-26. This graphic visually breaks down the permitted identification methods, showing that instead of the standard rule requiring taxpayers to communicate lot selections directly to their brokers, they can securely rely on internal book entries or internal standing orders. The graphic also contains a critical warning block in the bottom center. The FIFO default remains. If your clients fail to make adequate identification internally and fails to communicate it to the broker, the default chronological order orders the sales be on first in, first out. So keep track of this. Also, practical answer, if the client's broker accepts identification, that's going to be way better because then you have a third party indicating they got this notice on this day prior to the sale. And that's going to be a lot easier to get the IRS to accept than your client swearing that they didn't do anything wrong. Oh yeah, I had it there all along. I had it there. Yeah, I know it looks like looks like this is all from the same pen, and this looks like it might have been all written on the same day. But no, I didn't do that. Yeah, that's what we're going to have trouble with. Next up, another relief item in this case, right? Third overall major development. We're looking at administrative reprieve for businesses regarding the business interest deduction limitation and depreciation. The IRS has released Revenue Procedure 2026-17, providing highly anticipated transitional guidance for taxpayers looking to unwind certain real property and farming business elections that impact 163J. So, Revenue Procedure 2026-17 offers a critical second chance for taxpayers. Following the major legislative changes introduced by the One Big Beautiful Bill Act, OBBBA, right, this procedure permits eligible taxpayers to withdraw previously irrevocable elections under Section 163J7 and Regulation Section 1.163J1B15 III. Specifically, this applies to those who previously elected to be treated as electing real property trade or business, electing farming business, or an accepted regulated utility trade or business, which was a trade-off to get out of the 163J limitations. So let's talk about the background and why OBBBA has changed things a bit, okay? So let's talk about the history and the catalyst of the relief, right? Originally, under the Tax Cuts and Jobs Act, an entity could elect out of Section 163J interest limitations. However, that election was strictly irrevocable and carried a harsh trade-off. Elected entities were required to use the alternative depreciation system under Section 168G, which is a short way of saying straight line, no bonus, right? No bonus depreciation would be available. So you gave that up by making this election. Now, in July 2025, we had the One Big Beautiful Bill Act. And Section 70303A of that act struck the restrictive language in 163J8, restoring the taxpayer's ability to add back depreciation, amortization, or depletion when calculating adjusted taxable income. And that means that your ATI is higher, which means you might not have needed the waiver anymore. On top of that, Section 70301 of the One Big Beautiful Bill Act made 100% bonus depreciation permanent. Overnight, that election that looked like the right thing to do, at least if you were assuming that, TCJ would stay forever as is and they wouldn't go back and modify 163J, it flipped it for a lot of taxpayers. Suddenly, that election that looked like, well, we got to do that, we're never going to get any interest deduction, may have slipped to, oh, I can't believe, this is horrible because we're giving up bonus depreciation, pushing our depreciation well into the future. And we're doing all of this because we, thought we had this permanent law change that was going to, cause us to never get our interest deductions. So what we're going to do is, under Revenue Procedure 2026-17, the IRS gives an administrative answer. It's going to allow taxpayers to unwind these old elections to capture the dual benefit of the enhanced ATI calculations and the permanent 100% bonus depreciation. Now, question now is who qualifies and what are the mechanics for executing this withdrawal? Section 4 of this revenue procedure applies to taxpayers who made the qualifying election on a timely original filed return, or Form 65, for the 22, 23, or 24 taxable years. To execute the withdrawal request, the taxpayers must file an amended federal income tax return administrative adjustment request. Now, there is a hard deadline here. The filing must occur by the earlier of October 15, 2026, or the end of the standard statute of limitation on assessment of refunds, meaning you must abide by Section 6511 for refund claims. Finally, the provision, precision in your filing is paramount. The amended return must promptly display filed pursuant to Revenue Proc 2026-17 at the top and must include a formally titled statement containing the taxpayer's TIN and declaration of withdrawal. We are fully reversing, but that means we got to get the year that we made the election has got to be timely amended. And we may be running into some deadlines here. So be aware of that coming along here quickly. Because obviously 22 tax years, their year ends, basically, I should say their period ends at this point for filing for claims for refund for most on, the due date on 2026, which for pass-throughs, like a partnership may have already passed. That's a bit of a problem, but we're there. So again, right, we have that. And remember, everybody's got to get it done by October 15th of this year. It's going to see earlier of the two dates. That's going to be crucial. Now, what's the ripple effects of this withdrawal? When a taxpayer successfully withdraws, there's 163J7 election under this revenue procedure. They're legally treated as if the election had never been made. This requires a lot of recalculations. So remember, you've got a deadline coming up. It may be coming up quickly, and you need to do a lot of recalculations. Your amended return or AAR must include all necessary adjustments to taxable income, particularly the recalculation of depreciation allowed or allowable under Section 168 now that ADS is no longer mandatory. Additionally, you must be careful to make corresponding basis adjustments to the affected property. If there are modifications to any adjustments under Section 481, those must be accounted for as well. Importantly, practitioners must file amended returns or AAR for any succeeding years impacted by these ongoing collateral adjustments to ensure the basis and depreciation schedules match across all open years. So there's work to be done here if you want to take advantage of this one. So there is a major administrative reprieve, though, for partnerships that are subject to the centralized audit regime under the Bipartisan Budget Act. Generally, under IRC Section 6031B, BBA partnerships are prohibited from amending the information submitted to their partners after the original due date without explicit authorization from the IRS. Under Procedure 2026-17 grants that specific authority. Eligible BBA partnerships can choose to implement this relief by filing an amended Form 1065, with the amended return box checked and issuing amended Schedule K-1s to partners for the affected years, rather than being forced to file an administrative adjustment request or AR. So you have a choice. You can do either. The amended K1s, if you go that route, must include a specific statement noting the Revenue Proc 2026-17 withdrawal. Critical procedural note: if your BBA partnership or taxpayer is currently under IRS exam for 22, 23, or 24, you must provide copies of the amended filing to the coordinating revenue agent no later than the date you file the forms with the IRS. So now if you have an exam going on, you need to provide your amended return to the agent at the same time that you file the return. That's required. And remember, we've gone down the path before on these revenue procs. To get the relief, you must strictly follow the requirements. So don't miss that one if you're in exam. Finally, let's go back to the visual again. And again, those you online, those you on audio, I'll try to describe what we've got here. Right? The infographic breaks procedures down to three main categories: context, eligibility, and execution. Right? So that'll be there. This graphic highlights the OBBBA catalyst. Too many B's there. Showing the legislation restored depreciation add-backs for adjusted taxable income, made 100% bonus depreciation permanent, creating the incentive to unwind these old elections. On the bottom left, it details the eligible scope, 22, 23, and 24 tax years, for electing real property, farming, or regulated utility business. The right side of the graphic emphasizes the strict execution steps you must follow. Submit the amended 1065 or AAR, applying the mandatory filed pursuant to Revenue Proc 2026-17 label in red at the top of the all filings, and hitting the critical deadline of October 15, 26, or the end of the standard statute of limitations, in order to get this timely filed. So again, consider your clients who may need to make this sort of election or may want to, and start planning how to get all that done, because you've got, what's your deadline? That's probably the first thing to identify. What's our absolute deadline, at least for the 22 return? Next up, we're going to go to our fourth development. We're going to shift our focus to the ongoing saga of the Employee Retention Credit and ERC today. Now, this is a credit under Section 3134. It was also part of the CARES Act, and so it wasn't codified until late in the game. Only, for most taxpayers, only the third quarter of 21 was a 3134 year, right? But there was a massive backlog of ERC claims led to the aggressive new processing protocols by the IRS and consequently litigation. Now, I've had concern about this litigation from day one because I thought, which is really what the courts ended up doing, that in essence, this wasn't like a reg, so really Loper Bright didn't apply. Neither did the APA. And the relief for the taxpayer was simply go to district court, file. Now, I realize that's not practical for a lot of taxpayers. I also realize the plaintiff in this case is not the taxpayer, but the consultant who is being paid on a contingent fee basis, and of course, for whom all this slowdown is meaning their cash flow is becoming a bit of a problem, right? But let's take a look at a recent memorandum decision from the Ninth Circuit, unpublished. They didn't feel it was a big thing to publish. ERC Today versus McAnally, which provides critical insight into the federal judiciary handles these lawsuits brought by third-party tax preparation firms that were on a contingent fee attempting to stop the IRS's automatic disallowance program. Now, let's just say it hasn't gone well for them, right? And this case itself has gone through essentially three runs. One run in district court when they're going for preliminary injunction, which the IRS came close to losing. I think if you read that one. A second final decision where the court essentially said, well, no, I can't really give you the relief you're citing, right? That's kind of there. And the IRS did take the hint and speed up the program a little bit in the interim. Right, and we've got that. So we're going to kind of take a look at this issue, right? So now we're in the Ninth Circuit for the third try at this thing. So it's looking at a threshold issue of Article 3 of the U.S. Constitution standing within the context of the IRS's new disallowance during processing DDP program. You can't just take the government to court for something you didn't like about what the government did unless you have essentially standing. And Article 3 is the part of the Constitution that discusses what's necessary for that standing. right? So the IRS was faced over 1.1 million unprocessed 941X amended returns. So the IRS instituted a processing memorandum and began utilizing automated risk management models to categorically deny claims without individualized manual review. The plaintiffs in this case were tax preparation firms operating on a contingency fee agreements who sued for a mandatory preliminary injunction to stop the IRS from using these automated filters, arguing that the automated denials were arbitrary and financially harmed their business. As we're going to discover, our problem is going to be that these third parties couldn't get their fee from their clients because their clients didn't have to pay the fee until they got a refund. Which immediately, when I first read that, was like, that it seems like the wrong person's in court, right? Although I will admit that there is a California case where the taxpayer was the party in court, as I recall the history of this. But I haven't heard about any further developments there. That one may have been just when the IRS just went ahead and paid it out to get rid of the problem. That was also done, I think, before they got a formal denial. So, you never know. They might just kind of solved it quietly. The central question before the courts wasn't whether the IRS automated filters were perfectly accurate, whether these third-party prep firms had legal standing to sue the IRS over its internal processing methods. In essence, the wrong parties before the court and are before the court on the wrong issue. Okay? So, what led to this litigation? Well, as you know, the Employee Retention Credit originally enacted under the CARES Act 2020 and retroactively applied to many taxpayers, creating a ton of amended returns, resulted in massive floods of aggressively marketed claims. There were a lot of groups out there trying to sell everybody on filing ERC claims. You all remember that, right? The ERC mills. And everybody got emails every day, right? If you owned an accounting firm, you were getting emails both trying to get you to sign up with these people and send your clients to them, but also got it because you were a business owner, so you were just getting it from that standpoint. So you all remember all of these. By late 2023, the IRS had a backlog exceeding 1.1 million unprocessed 941X returns. And that's a problem because remember, this was a relief program to give business funds to stay in business during COVID. And the program had effectively ended for most taxpayers by September 30th of 2021. As a practical matter, my own belief is it probably really ended for most taxpayers somewhere earlier in 2021. Because even the states had some of the broadest, COVID lockdown rules. Yeah, they were basically gone by the time we got to the third quarter of 21. In response, the IRS instituted a processing moratorium and implemented the Disallowance During Processing, or DDP program. This DD program utilized automated risk management models and entity-level filters to categorically disallow thousands of claims without any individualized manual review. It was a mass issuance of letters 105C and 106C that were summary denials. Your claim has been denied, period. Right. The plaintiffs, ERC Today and Stenson Tamadon, LLC, are tax preparation firms operating on contingency fees. They sued for a mandatory preliminary injunction to stop the IRS from using these automated filters, to restore manual processing, and to vacate the automated disallowances. Now, stepping back, one thing from the beginning was, I'm not sure what they thought would happen. Where are we going to get the people to process these? In essence, the IRS is probably not just going to send checks to everybody. So it was kind of like, I didn't see that this could be a timely way to fix it. But nevertheless, they kept going because, one sense, I guess their theory was, well, they have to lose. Right. So now we look at the legal hurdle here. Article 3 standing. To sue in federal court, a plaintiff must establish injury in fact, causation, and that the court can do something to effectively redress that injury. And our problem here is going to be, this issue. District Court initially denied the injunction on the redressability prong, noting it was merely speculative whether enjoining the program would actually result in a higher approval rate of the plaintiff's clients, especially given prior TIGTA findings of over-approvals during manual reviews. As I noted, my concern from the start, yeah, you win. What happens next? It's probably not going to be what you expect, unless you want the court to order them to pay them all out. Now, the Ninth Circuit reviewing the case de novo affirmed the denial, right, by dismantling the foundations of their claim, the injury in fact. Because they were seeking a preliminary injunction, the plaintiffs were required to make a clear showing of financial harm. While they alleged lost revenue and increased post-disallowance, representation costs, that they had no record in evidence proving any of that. Right? They provided no data showing that their aggregate rate of approvals dropped or that their costs actually increased during the program compared to the traditional manual reviews. So the Ninth Circuit said, ignore the fact of, whether this could be redressed. We're not even accepting that you've shown an injury because you failed to produce proof, at least per the Ninth Circuit's review of the record. There was no proof produced. So there were three alternative theories of harm the tax preps tried to claim, all of which the Ninth Circuit rejected. First, they claimed procedural harm. The court shot this down, citing Sterling versus Feek, noting our administrative review procedures are designed strictly to protect the financial rights of the taxpayer, not the economic interests of third-party contingency fee firms. You aren't the party for whom those administrative protections are met. You can't sue. Wrong party suing. Second, they claim representational harm. Under Sweet versus Cardona, reputational harm requires disparagement. Because the IRS's DDP letters sent to taxpayers did not identify or even refer to these tax preparation firms, there was no cognizable disparagement. They just said your claims disallowed. They didn't say, oh, these guys are so incompetent. They obviously didn't do any work. They whatever. They didn't make any statement like that. They just disallowed it. We've all had cases, every firm, has had a situation where ultimately on exam, the IRS disallowed something and sometimes even had them go to tax court and the tax court agreed with the IRS disallowance. That's not disparaging the CPA firms or law firms that were involved in representing the taxpayer and arguing for the case, right? That's going to be a normal expected thing. So they said no. Finally, the plaintiffs claimed a regulatory harm, which this court rejected under the Supreme Court's Clapper standard, characterizing it as a highly speculative fear resting on an attenuated chain of possibilities. In essence, it was all speculative harm based on this regulatory harm theory. So here's the holding and the practical takeaway. The Ninth Circuit affirmed the denial of the preliminary injunction because the firms failed to make a clear showing of standing. They declined to even reach the merits of whether the IRS automated filters were arbitrary. However, the appellate panel did remand the case, noting that under the liberal amendment policy of the Federal Rules of Civil Procedures 15A2, plaintiffs should be given leave to amend their complaint to try and cure their lack of evidentiary support for the financial injury. You can go back and relitigate this again. Of course, we're getting so drawn out in this particular litigation that you got to wonder, is this really helping anymore? We'll see if they try it. It's a tricky takeaway. While the IRS's automated ERC dishonors procedures were incredibly frustrating, are to this day to some extent, third-party professionals generally lack legal standings to challenge these administrative processing rules directly. You can't sue the IRS because their internal processing methods hurt your firm's profit margins, right? They hurt your cash flow. You got to remain focused on client-level substantiation and guiding your clients through post-disallowance administrative appeals and refund litigation. Like it or not, here's where we stand, right? What you have right now, if you saw a client the IRS hasn't acted on the claim yet, you filed over 60 days ago, your client has redress. You won't like it, but they have redress. I remember being in a CPA session once at a conference, and the speaker who used to work for the IRS was, of course, was getting kind of along these lines of, well, they got to do something about that. That's not valid, can't be done. It's like, and I'm saying, I know, the taxpayers have no way to get their refunds. And I said, I don't want to be too nasty about this, but they clearly do have it. It's not practical, but the courts rarely worry about practical because we don't worry about that much in the legal system. In fact, you can't afford to go to court. Doesn't change the fact you have court. You have court as an option. So, and that's kind of the argument here. Your clients may not, it's obviously, if you're talking about a $50,000 ERC refund claim, it is almost certainly not cost effective to attempt to litigate that and sue for a refund in district court or the court of claims, your two options. But you have the right to do so. And there's no other way to force that 50 grand out aside from going down that path. So bottom line, clients who are, and this is what attorneys I know that were working some of the ERC stuff were telling people, it's like, we haven't heard from them. Can't we speed up? And the answer usually was, if it's I'll take a look at the facts of the case. If the facts of the case is based on revenue and we got solid books, then yes, because in essence, I'm pretty sure counsel's office will turn that down, or it says the Justice Department will quickly concede that case, right, and pay it out. But if you're talking about this partial shutdown theories, and it's not, and you're trying to use things like, the ones the IRS claims they won't go along with, it's likely you're not going to get anywhere. In essence, you're probably better off waiting to see if they allow part of your claim, rather than being the person that's actually gone out there and tried to, advance what rules count in this case. And unfortunately, because very, very few cases, and it could be the IRS just paid those out. I'm not beyond believing that one, they just paid those out to avoid getting anything on the record. When people literally substantively threatened to go to court, those are cases we needed. This case I knew wasn't the case we needed, because even if they won, I didn't think we got anything. And unfortunately, the courts kind of agreed with that. So again, we have our nice little picture here. It talks about the failure of the legal strategy in this case, right? It's collision between the plaintiff's challenges on the left and the court's verdict that's on the right. Left side highlights the automated DDP filters and the contingency firm's claim of financial industry. The right side shows exactly why the court sided with the IRS. It highlights the failure to prove standing, but also brings an important district court ruling, Administrative Procedures Act. There was a lack of any final agency action. Under Title V United States Code, Section 704, the internal risking model used by the IRS to filter returns is merely an internal procedure. It is not the final allowance or disallowance of an individual tax claim, meaning it is not subject to APA reviews. Right? They didn't put out a reg that says, if you're trying to use basically, the fact that the harbor was shut down, so the import stopped, and that was due to, people having to go get COVID vaccines, etc. If that was your theory, and they did a reg that said, yeah, that can never work, that's a substantive rule. That's where APA could work. But this is merely their process. They're allowed to have an opinion. If their opinion is wrong, you challenge that opinion in court. That's how this goes. And so, there were proper remedy lies in alternative taxpayer remedies. Going to appeals, remembering that in a claim for refund, the statute of limitation continues to run while you're in appeals, so watch that clock carefully. And litigation brought by taxpayers themselves, not by the prep firms. So that's the way this works. I'm not surprised. I wasn't from early on that it was going to go here. Okay. And I should say, especially was not surprised when the IRS did speed up the program after the district court in Arizona here kind of prodded them. And once that was done, it's like, the judge, I think, pretty much saw that right away. If they do speed up, I have no idea, what they're going to do. So they sped it up. And so fundamentally, I think this in the end just caused more disallowance notices in some of the litigation to come out faster, which I guess that's good knowing, but it's about all we know. Next up is going to be the fifth development, where we have some welcome administrative relief regarding vehicle substantiation, but for a very limited subset of vehicles. Our Treasury Internal Revenue Service recently issued final regulations under Treasury Decision 10,043. These regulations officially expand substantiation exceptions under 274 for certain unmarked emergency vehicles, and that's why it's narrow. Your client, who's running a plumbing business isn't going to help you. Just going to say nothing changed there that helps you. For anybody, though, advising municipal employers or individual first responders, these rules have an immediate and highly favorable resolution to a fringe benefit issue that they may have run into. Okay. So let's overview the regulation. The core topic here is the expansion of the substantiation exception for unmarked emergency vehicles. Previously, the vehicles had to be marked. The significance of this ruling is it formally expands the regulatory definition of qualified non-personal use vehicles to include very specific unmarked vehicles used by firefighters, rescue squads, and ambulance crews. Okay? By qualifying under this definition, these vehicles are completely exempted from the strict record keeping and mileage logging rules that normally apply to employer-provided passenger vehicles. So, what happens here is let's talk about the statutory context of these regulations. As you know, Section 274D imposes strict substantiation requirements on listed property, which includes any passenger automobile. The statute requires taxpayers to prove the amount, time, place, and business purpose of every mile driven, or the fact that it wasn't driven for business, right? However, there's a statutory carve-out in Section 274I, which state the strict rules do not apply to qualified non-personal use vehicles, meaning vehicles that by their very nature are highly unlikely to be used for more than a de minimis amount of personal travel. Prior to these final regulations, Treasury Section 1.274-5K to I provide a very rigid exclusive list of these vehicles. And the exception that's key here was it accepted clearly marked police, fire, and public safety vehicles, and unmarked vehicles strictly used by law enforcement. So law enforcement is the only one that could get an unmarked vehicle under this clue. So if you're a fire department, you're an emergency, you're paramedics, etc. Now that could never work, right? So firefighters, rescue squads, and ambulance crews were entirely excluded from the relief, and were subject to full substantiation rules if they were provided with a vehicle that was unmarked, but meets the requirements that are provided in this regulation. Okay. Now, why did the IRS change this rule? This change stemmed directly from evolving safety concerns. Treasury acknowledged that governmental units are increasingly assigning unmarked vehicles to emergency responders to mitigate the rising incidence of harassment and vandalism, specifically targeting marked fire and emergency vehicles. Allowing responders to use unmarked vehicles allows them to travel inconspicuously while off shift but on call. Furthermore, the IRS noted that these vehicles are so heavily and specifically modified with emergency gear that any personal use beyond commuting is naturally going to be minimal, bringing them perfectly in line with the underlying legislative intent of Section 274I. Now, what are the requirements, though? Not just give an unmarked vehicle and say that and we're good. Because they realize what happened then is you'd be giving people vehicles which really don't have any of that equipment, but then claiming you could ignore it. So there are some very specific rules here. Right? There are 4 strict criteria found in Treasury Regulations Section 1.274K7. First, it must be used by a firefighter or a member of the rescue squad or ambulance crew who is explicitly required to be on call at all times when not on a regular shift. Second, the employee must be required by their employer to use the vehicle for commuting. Third, this one's critical for compliance. Personal use of the vehicle outside of commuting and emergency responses must be officially prohibited by the government's unit policies. And you need to show you're actually enforcing that. And finally, the vehicle must be specifically outfitted for emergency response. This means it must be equipped with items like built-in lights, sirens, medical emergency equipment, life-saving devices such as defibrillators, and two-way radios. Now let's take a look at the practical impact of these requirements. While an unmarked vehicle qualifies under these rules, the tax treatment is highly favorable for both the employee and the governmental unit when they meet the requirements. So the first responder, the value of the vehicle's use is completely excluded from gross income as a working condition fringe. So essentially get free commuting. Right? That's kind of helpful. So they don't have the tedious burden of logging mileage for commuting or de minimis personal errands. And de minimis personal errands while on the job means, like they're out, they're on the job, they're driving around in this unmarked vehicle. And while they're out there on the unmarked vehicle, they end up, stopping for lunch. Well, that's personal use. Driving through McDonald's is not a requirement of your emergency responder, but that's de minimis. And it's done while they're within their general rule of, driving while on duty. So it does do that, right? Right. So if you're a municipal employer, no additional employment tax reporting or new substantiation requirements aside from getting the policies in place. And finally, regarding the effective date, these reprieves are available immediately. The Ability Damage Trade Regulation 1.2745M states that these rules apply to taxable years ending on or after March 20th, 2026. So immediate there. Now back to our wonderful little illustration here, right? This is, right? The graphic contrasts the problem and the solution. On the left side, it illustrates a heavy administrative burden of detailed mileage logs and the very real safety risk of harassment, associated with mandatorily marked vehicles. On the right, it maps out the new exemption. Enhanced personal safety by allowing inconspicuous travel and simplified substantiation where the vehicle use is treated as a working condition fringe benefits. At the bottom, it visually reiterates the strict eligibility requirements that we just discussed. The vehicle must be specifically outfitted, and the employee government unit must strictly prohibit personal use outside of commuting and emergencies. But this is a really neat side benefit for the employee and the employer, as long as you live by the rules. Right? That's probably the tough part. In essence, you got to make sure that you don't turn a blind eye to personal use. If that vehicle somehow ends up, getting ticketed, you're the Phoenix, you're Phoenix Fire Department, and your fire vehicle ends up being ticketed, by a highway patrol officer in Montana, and there's no reason for that truck to be in Montana, and you discover that, your employee just took it on vacation, used that on vacation rather than taking his personal car. You need to take some action on that. That's going to be the fun part there as we go. Okay, next up, our sixth development of the week. I told you I had a bunch. This is a significant new case that is going to look at the centralized partnership audit regime enacted by the Bipartisan Budget Act of 2015, commonly known as the BBA. The reviewed opinion in Jones Bluff LLC versus Commissioner, tax court case, or 166 TC number 6, I should say. This case holds substantial implications for partnerships and addresses fundamental constitutional questions regarding how BBA audits are conducted. Can you imagine a constitutional question? We don't see that often in the tax court, but we did today in this case. So let's take a look at the case overview here. The core issue litigated in Jones Bluff goes straight to the foundation of the Bipartisan Budget Act regime's entity-level framework. The question before the court is whether a partnership possesses the legal standing to assert the Fifth Amendment due process rights of its individual members in an attempt to invalidate a notice of final partnership assessment, or adjustment, I should say, or FPA, because the BBA fundamentally altered who is considered a party to an audit proceeding. The tax court had to carefully analyze the boundaries of third-party standing. We're back to standing again. Do they have the standing to raise this question? Now, let's talk about the factual background here. Jones Bluff LLC was an Alabama limited liability company treated as a partnership. It was subject to the Bipartisan Budget Act rules for its 2019 return. In 2019, the partnership granted a conservation easement, does that sound familiar? Over a tract of land and subsequently claimed a massive charitable contribution deduction of $36.29 million under IRC 170. Whereas audited return and in October 2023 issued an FPA completely disallowing the deduction. Not surprising, we've gone through all these cases, so we got yet another one here. This is an asserted imputed underpayment under BBA of roughly $13.4 million and penalties exceeding $5.3 million. So in essence, $18.7 million is what we're looking at here. In response, the partnership did two things. First, it submitted Form 8988 to make a Section 6226 election to push out the adjustments to its reviewed year's partners. And second, it petitioned the tax court, immediately filed a motion for summary judgment, claiming the entire BBA audit regime violated the Fifth Amendment due process clause. Now, obviously, I think part of this is driven by concerns that they're reading the tea leaves and noting how these conservation easement cases have gone so far in the tax court. Well, every case is different. You got to be at least a little concerned your case isn't different enough, to go ahead on the merits. So they're going to try to get this thing, invalidated up front and be outside statute. So, we're great. So let's look at the constitutional challenge that they're raising, right? The partnership filed a motion for summary judgment arguing that the BBA audit rules fundamentally violate the Due Process Clause of the Fifth Amendment, which prevents individuals from being deprived of property without the due process of law. Now, the partnership argued that the BBA deprives the individual partners of this due process. The statutory framework does not provide them with direct notice of the adjustments or a direct opportunity to be heard. Now, the majority opinion contrasted this with the legacy TEFRA rules. Under TEFRA, the Tax Equity Fiscal Responsibility Act, going back to 84? Yeah, it's way back there. Individual partners were treated as parties to the judicial action and had participation rights. Some of them were. Under the BBA, however, the partnership is the only party that can initiate judicial proceedings. And liability derived from the adjustments is strictly the partnership's liability as an entity. Because constitutional rights in question technically belong to the individual partners rather than the partnership entity itself, partnership are attempted to rely on the third-party standing doctrine to raise these claims on behalf of their partners. So let's take a look at the court's analysis of do they have standing. While the partnership met the Article 2 standing to challenge the FPA itself, invoke constitutional protection on behalf of another party requires overcoming some rather severe prudential limitations, I should say. Citing the Supreme Court's case in Kolowski versus Tesmer, the tax court noted that a litigant must demonstrate two things to bypass restrictions: a close relationship with the possessor of the right and a hindrance to the possessor's ability to protect their own interest. Assuming there was a close relationship, and the court kind of granted that likely that they could meet that one, the partnership's argument fatally stumbled on the hindrance prong. The court found no hindrance preventing individual members from asserting their own constitutional claims in the future. Because underlying liability on the BBA is entity-level liability, if members face tax liabilities only because of partnership's affirmative 6226 push-out election. The members can remain entirely free to raise the due process claims on future partner-level litigation, such as a refund action or collection due process proceeding under IRC Section 6330 or 6320. Wrong party in front of the court, again, is the argument, right? At least on this issue. On the other issues, no, right party's there. That is the substantive question of, is that conservation easement valid? And, is the value proper? But like I said, I think if you're in that industry now, you're getting a little concerned going back to the tax court to ask that question. Oh, no, we got it right. Nobody else has yet, but we got it right. Probably would like to win this way if you can. Actually, even if you had it right, prefer to win this way. But, what the heck? Take the easy way out. So, citing the case of Texas versus United States, the court explained that claims are not ripe if they rest upon contingent future events. Because the BBA assesses liability at the partnership level, any potential deprivation of the member's property was purely speculative at this stage. That deprivation would only occur through contingent future events, namely the partnership using 6226 statements after the decision became final or failing to pay the imputed underpayment. They tried to accelerate this, right? Consequently, the court held the partnership lacked third-party standing and the due process claims were not ripe, denying the motion for summary judgment. Now, note, the majority opinion did not say there isn't a due process issue. They just said you're not the party that can ask that question. In concurring opinions, a number of tax court judges went the next step and said, and we believe that there's no due process issue anyway, even if we went forward through the entire rights of the individual partners, we believe they have a valid enough due process option that it's not a problem. But again, that was concurrent, not a majority. So, kind of keep that in mind. They so far, most of the tax court is reserving judgment because it won't come from them. It'll come from the district court. It's probably the reason why they did. So another infographic, right? We do the infographics now. Remember that, right? We do that. This comparison between the old TEFRA rules and the new BBA regime. Left side is the old TEFRA rules, right? How they did it. Adjustments happened at the partner level, and certain partners had direct notification rights. Right? Remember, not all did. Not everybody was a notice partner if you're in a partnership. With the new BBA rules, where adjustments and litigation authority lies solely with partnership entity, that's different now. Used to be at least some partners had the right to go to court independently. But now it's just a partnership entity. The right side of the graphic visually maps out exactly why the court denied standing. It is fair to establish third-party standing due to lack of hindrance. Why the ripeness issue, right? Basically, I should say, the ripeness issue, I should say, emphasizing the partner's level's injury relies on contingent future events. The ultimate limitation that a partnership cannot raise Fifth Amendment due process claims on behalf of individual members. So, all kind of important things to keep track of. But yeah, the Fifth Circuit BBA claims, those are going to have to come in later types of litigation. Doesn't mean mean it's not there, but it just means that the tax court said, don't need to decide this here. We're not going to. Next up is going to be the seventh and final development, right? We're going from partnership level tax controversy down to individual taxation. We're going to look at the taxation of Social Security benefit repayments and, very importantly, the concept of the claim of right doctrine and the claim of right code sections. Because what we're going to find here is that, unfortunately, this pro se taxpayer that went to court on his own, there was a way that could have recovered most of what he wanted. Almost certainly. We don't know the exact facts, so I can't say for sure, but I would think there's a reasonable chance we could recover a lot of what he claimed. But we would have to have gone a different path than he went. In essence, he litigated the wrong year. Okay. So, this decision in the case of Smith v. Commissioner, Tax Court Memorandum Decision 2026-25, issued on March 19th, is a reminder of the rigid timing rules surrounding taxation of benefits, and serves an excellent case study on the realities of the claim of right doctrine and recoveries under that, and how harsh it is, and how you appear to be going after the wrong year, but you've got to go after, quote, the wrong year to actually be the right year. We'll talk about claim of right here as we go through this case. So, what's the specifics of this case, right? The core topic here revolves around the taxability of Social Security prepayments and the application of the claim of right doctrine in those cases. Those of you handling individual tax compliance, the case highlights the incredibly strict statutory timing rules for offsetting taxable Social Security disability benefits or SSDI benefits. Right? It's a textbook to exemplify attempting to net out income across different tax years without following this precise statutory mechanism will result in deficiency being sustained. Bottom line, deductions must be claimed in the proper tax year. Income must be recognized in the proper tax year. And the problem here is, if we talk claim of right, we're going to discover we're going to recognize the income in the year we're paid. We're going to get the relief, either a deduction or a tax credit in the year that we pay back the amount that was basically taxed under a claim of right doctrine. And the problem is, people naturally want to offset, especially when we describe the situation that this taxpayer faced. So, let's talk about this timeline. During the 2022 tax year, the taxpayer, Michael Smith, was employed and received wages, but he also applied for Social Security disability benefits claiming a disabling injury. The Social Security Administration ultimately approved his claim and paid him $26,802 in retroactive and current benefits during 2022. Mr. Smith did not report any of these benefits on his 2022 Form 1040. In 2023, the Social Security Administration discovered that Mr. Smith had been concurrently employed. That's not a good thing, getting Social Security disability. Just going to tell you right off. Yeah, the entire time, and determined he was never actually entitled to any of the benefits. They demanded their money back, and Mr. Smith complied with paying over $31,000 Social Security Administration across 2023 and 2024. Obviously, he got paid some going into 23 before the Social Security Administration realized the problem. Now, the IRS audited his 2022 return, and they assessed a tax deficiency. Because his income exceeded the base thresholds, the IRS correctly determined that 85% of the $26,802 in benefits received in 2022, or $22,782, was required to be included in his gross income under IRC Section 86a. Taxpayer didn't like that way of looking at it, right? So how did he try to defend himself against this assessment? Mr. Smith did not contest the 85% calculation. Smart, right? That's very black letter law. There's no real way out of that, right? It says argument was that the 26,802 was essentially an accidental overpayment or loan from the government, and therefore it should be excluded from his 2022 gross income because it was forced to return it in the following years. That makes sense to somebody just sitting out here, an average third party, even a well-educated, intelligent third party. It would seem to make sense. I got paid this, but I paid it back, right? So I shouldn't have to pay tax on it, right? It wasn't mine. It was an erroneous payment. And so it wasn't really my income to keep. But the problem is the tax court went after the argument, right? Using fundamental principles of tax law, right? The court relied heavily on the annual accounting principle. That's a key one we have. Under IRC section 451(a) and Treasury Regulation 1.451-1A, which strictly requires cash basis taxpayers to report items of gross income in a specific tax year they are received. And the catch here is you can only do things based on what has happened by December 31st of your 2025 return right now, December 31st, 2025. Assuming a calendar year taxpayer. It doesn't matter what goes on a week into 26. Doesn't matter. It was not something that happened in 25. On accrual, we generally get into more, was it known or knowable at December 31st? You got to show it. The annual accounting method says, in essence, fundamentally part of the annual accounting method rule is I should create the same exact tax return. If I file that return on, let's say, at the stroke of midnight on on December 31st, 2025, that return should be identical to a return prepared on October 15th on the extended due date. We don't care about what happened between January 1st and October 15th. For the most part, there are some exceptions. For the most part, we don't care about that. So that's the key. And of course, as of December 31st, 2025, he had the cash in hand. And he didn't yet know he's going to be asked to repay it. Now, what about that repayment, though? The court invoked the claim of right doctrine from the 1932 Supreme Court case, North American Oil Consolidated versus Burnett. This doctrine, and there are related code sections that provide relief in certain cases from this doctrine, that provide relief, but on a very specific method that the taxpayer didn't use here. If a taxpayer receives earnings under a claim of right and without restriction as to its disposition, he received money that he might need to pay back. In fact, did need to pay back fundamentally. But when he was given the money, there was no restriction on his disposition of that. And it's contingent. We don't know if he's going to have to pay it back. Right? It wasn't part of the deal, right? It's possible, because it's always possible. You apply for Social Security benefits, and you might have to pay them back. If it turns out you weren't eligible, you claim to be 65, but somehow you fooled the whole system and you're not, or let's say 62, you went for benefits, but you're actually 58. I'm sorry, those benefits are going to be asked to be paid back if they figure out your age. It's the same difference here. Disability, figure out that you were working and you weren't prevented from working by your disability, they're going to require the money back. That's how they go. Right? So even though he was later required to return the money, he had to pay tax on it. Because he applied for the benefits and Social Security Administration immediately affirmed his entitlement, he received those funds under a valid claim of right in 2022, making them taxable in that year. There's a recovery method, but the recovery cannot take place until the year or years in which the funds are repaid. That's going to be our key takeaway. Mr. Smith is litigating the wrong year. Now, the tax court firmly rejected the taxpayer's attempt to offset his 2022 income with the repayments he made in 2023 and 2024. Under IRC Section 86D2A, Social Security benefits are reduced only by any repayments made by the taxpayer during the taxable year. Because Mr. Smith did not make any repayments in 2022, the court was legally bound by the code and could not adjust his 2022 liability. The court noted that Mr. Smith clearly received the funds under a claim of right because he had actively applied for the benefits. and had received an award letter affirming his entitlement. The restriction on his right to those funds did not arise until the following year, so his administration learned of his ongoing employment. Therefore, basically the court ruled that any relief must be determined strictly for the tax year in which repayment was actually made. That's the requirement under the claim of right doctrine, right? You're allowed to, under the claim of right reg or claim of rights sections that we have under 1341, you're allowed to claim, as long as there's more than a $3,000 amount involved, you have an option to either take a deduction in the year you repay them for the amount you paid back, or to the extent it was included in income. You got the 85%, you can't get a deduction for the full amount you paid back, since 15% of it was never an income. Or you can do a recalculation of the tax from 2022 in this case, determine how much tax would have been due had you not, had we simply not, had we not received the amount we repaid in 23, how much would have been due, and then that's your tax credit. You got your choice. Now, some states follow that option, some states don't. So with states, always check claim of right because weird things happen. That's your background. So let's take a look at that correct strategy. Although the judge did not rule on this in the 2022 deficiency case, he mentioned in passing, he should have sought relief on the claim of right statute 1341 on his 2023 return. Under Section 1341A1 and Treasury Regulation 1341A12A, taxpayer including item of gross income under unrestricted right, but later established they did not actually have that right, can obtain targeted relief if this deduction, if the reduction for the repayment exceeds $3,000. Since he repaid over $31,000 in 2023, he clearly cleared this threshold. Well, he actually did 23 and 24, but I'm going to assume it's over $3,000 in both years. And probably 3,000 divided by 0.85 because really 85% is being included. We'll ignore all those little details for now. Let's just take the simple case. Let's assume he had done it 23. He would have taken a $31,000 deduction in 23, or he would have gone back to 22 and calculated, basically taken out the entire, in this case, he would have repaid everything, taken out the entire Social Security benefit from the taxable income computation, figure out how much his income went down, which we kind of already know because the only adjustment the IRS made was to charge him for what the Social Security would have been, what tax would have been Social Security. So, yeah, he was just taking that credit in 23. Unfortunately, it seems very, very likely that he never filed a protective claim for refund. The court never mentioned that. The court didn't like twist the knife and say, well, no, what you have to do is you have to go to court and sue to, get your refund from 23. But tough luck. You hadn't already filed court case. So you're just out of luck. Sorry. You made a gift to the government. Probably not good. So the key warning is watch out for this claim of right concept, 1341, and the rules under it. When it tends to come up, people get signing bonuses, right? But they have to pay the bonus back if they don't stay on for, let's say, 5 years, right? There are various other things like that do that, right? They have a loan, but everybody knows the loan from the employer is going to be basically waived over the next 5 years. If it's all with a wink-wink agreement, the IRS can argue claim of right and saying, nope, there was no intent to recapture that loan, that's income. Yes, you had the legal right to do so, and you would have done so if he quit. But, but basically the assumption is that he's going to stay and earn it through. So there have been a couple of cases like that. So where do we stand at the end of the day? Well, let's take a look at our graphic here. 1341 is probably the big thing here. Understanding the claim of right. Now, there is a two-step lesser of computation required in Regulation 1.3411B. Determine the tax benefit. You illustrate the Section 1341A calculation, which computes the current year tax with restoration deduction taken into account, tax deduction. Contrast this with the Section 1345A5 calculation, which computes the current year's tax without that deduction, but provides a refund of the prior overpayment by subtracting the decrease in tax from the prior year that results in excluding the item. This is this infographic we have, which is in the downloaded slides on the website, currentfederaltaxdevelopments.com, on the audio and video presentations. Yeah, kind of illustrates claim of right. Claim of right, you'll run into it a few times in your career, and you always have to go back through it every time. But remember, the key trigger is they got money, right? There were no restrictions placed on that money. But then at some point in the future, a contingency causes them to have to repay that back. That's a claim of right case. And part of the reason why it's structured that way, to be totally honest, and why Congress wrote the law that way is because 1341 applies and gives you the break in the year of repayment, even if that year of repayment is outside your statute for claiming a refund for the year you first received it. So claim of right can be a better solution in many cases, but it's not optional. You got to use it. Doesn't matter if it's better or worse. You got to use the claim of right options in cases like this. Well, this wraps up this week's overview on tax issues, current federal tax developments for the week of March 23rd, 2026. As always, if you have questions, my email address is on the slide there. It's Zollars@currentfederaltaxdevelopments.com. You also can, if you want to, try to get me in certain state society connects groups. I do it for Arizona, New Jersey, Idaho, Illinois, Minnesota, Washington. So you can keep an eye on there. If you post something there, I might respond to your question. Otherwise, we hopefully will be back next week. Again, late tax season. I can't guarantee these are going to keep coming on schedule. Just kind of the way late tax season works. But if possible, we'll hope to be looking to add stuff in next week, see what's going on. And you guys can then tune back in here on Current Federal Tax Developments.